The United States Supreme Court shall come to order to hear case docket ending 2011-2012 Chester Comerford versus the United States of America. Is petitioner's counsel ready to proceed? Yes. Respondent's counsel?
Yes, Your Honor.
Mr. Wallach?
May I begin? Chief Justice, Your Honors, and may it please the Court. My name is Andrew Wallach, and I will be arguing that the petitioner's Fourth Amendment rights were violated by the search in question. My partner, Alwani Salebo, will be arguing the First Amendment issue. I'd like to take this opportunity to request 2 minutes for rebuttal.
It is so reserved.
Would the Court like a recitation of the facts?
That is not necessary. Please begin.
Your Honor, the case at bar is about a government search that violated the private communication rights of my client. I will argue that the government action was a search and was unconstitutional because it first infringed upon the petitioner's reasonable expectation of privacy, and second, it subpoenaed an improper party lacking common authority, and third, the Stored Communications Act does not contain protections equivalent to a warrant. Turning to my argument, we request that the Court adopt the ruling in Warshak v. United States and hold that communications sent via the Internet be protected by the Fourth Amendment. A main differentiating factor between the current case at bar and Warshak is the type of communication involved.
But didn't Warshak reference emails specifically? This is a chat room, and couldn't the argument be made that the reasonable expectation of privacy is mitigated by the presence of 200 members?
Your Honor, Warshak did involve email. However, emails and chat messages are functionally equivalent, and in the case at bar, as in emails, the certain audience was selected. In the case at bar, the only people who were to join, and reasonably thought by the petitioner, the only people who would join, would be people who were like-minded and who wanted to discuss Guardian philosophy. The petitioner had a reasonable expectation of privacy that no one who did not want to reasonably discuss and peacefully discuss Guardian philosophy would be in that chat. He enacted security measures that enhances his expectation of privacy, both subjectively and according to society, to prevent uninvited eyes, like those of the Secret Service,
Didn't the petitioner, in fact, waive any expectation of privacy by merely putting this chat room together out in cyberspace for all to see at perhaps some point in time?
Your Honor, I'd like to make clear that the expectation is a reasonable expectation. It is not an absolute expectation. By communicating via the Internet, which is such a prolific means of communication in this day and age, there is the inherent risk that the messages are sent via a third source. It's necessary that you create a website and a chat message or a chat room by using an Internet service provider such as Denulf. However, just because there is a passage of information through a third source does not mean that Fourth Amendment protections are necessarily gone away with. In United States versus United States District Courts, as found in Warshak, it was decided that the very idea of information passing through a third source necessitates the application of the Fourth Amendment. And this broad construction of private communication rights has been founded in several cases, such as Katz versus United States, that afforded citizens the right to communicate privately. In the case at bar, the petitioner's private communication rights were violated because, one, an improper party was subpoenaed. Because the documents or because the chat messages were sent to Denulf, they did have some sort of access. However, their access was done with proverbial blinders on because of their promise not to monitor content. The promise not to monitor content enhances the petitioner's expectation of privacy.
Well, counsel, the record at footnote 6 indicates that this lack of authority would not be implicated where proper legal authority exists. So isn't the question really whether the SCA is constitutional?
Your Honor, it is in effect whether the SCA is constitutional. And however, I'd like to address that the very fact that a proper legal authority will be able to subpoena the documents and take them or require them of a warrant is simply commonly known. It's whenever a warrant is delivered or whenever a proper legal authority delivers something or delivers some sort of order, of course the documents will be turned over. That's logical. That does not mean that the petitioner necessarily gives up his expectation of privacy.
In the court's opinion in Kylo, although they found that the use of the surveillance was not necessarily known to the public at that time, the rule did stand that it is what the public can expect the technology to be used upon them. And can't we say now that through the many years we've been using the internet and all this technology to communicate with others, that the public is aware that the government or even a third party such as Denulf Communications can not necessarily does because of contractual obligation, but they can. They do have physical access to the information.
Yes, Your Honor. It is known that people can, or that the government can compel.
So then how is it reasonable if that's the standard we applied in Kylo?
Your Honor, it should not be this way that the government can compel. And I'd also like to point out that in Kylo, that communication involved, or that use of a device, was found to have violated the petitioner's expectation of privacy because it was a form of technology not in common use. And in the case at bar, the petitioner could not have expected that the instant message reflector would be able to take both contents used in the past to store it under TNOLF and to take content that was to be taken, that was to be said in the future.
It's not the petitioner knows that the reflectors exist. It's does the society have a reasonable expectation, or do they have a reasonable knowledge of such technology, or the use of government intervention into these facts?
Your Honor, society does not recognize this because this is a new technology. This is a technology that was not necessarily in use as stated in the record. And even more, the society must recognize this expectation as reasonable, because if not, it would lead to the implication that no one on the internet, anywhere in any regard, has any sort of privacy in word or content. Warshak writes that lovers exchange sweet nothings and businessmen swap ambitious plans, and people communicate with their doctors and hospitals via the internet. If the government were to retract any sort of expectation of privacy on the internet, it would take away the very foundation of how we communicate. The internet is such a prolific means of communication that to not give it any sort of Fourth Amendment protections could change the way in which society interacts.
Well, counsel, those three illustrative examples you just mentioned suggest two people. Lovers exchanging sweet nothings is two people. Doesn't it change the inquiry when it's 200 versus 2?
Your Honor, it cannot change the inquiry because the court has never said specifically that a number of people mitigates or violates a certain expectation of privacy. And even more, in the chat room, there was security inactions. It was the best that the petitioner could have done to ensure that no one who did not want to peacefully discuss Guardian philosophy would be able to do so. And even more, the statute in question, the Stored Communications Act, is not something that's equivalent to a warrant as required in Illinois v. Kroll, pointing to the fact that the government has gone beyond its means and violated the petitioner's expectation of privacy and also violated what society expects to be a reasonable procurement of content.
Well, counsel, the means of access to this chat room, I mean, we've heard about these elaborate passwords and protections, but in fact, all you needed was $100 and to sign a pledge that you would keep whatever's in there anonymous. Isn't that it?
Your Honor, this is
But I mean, a federal agent, for example, could have signed up and gotten in and listened on that, and he wouldn't have been violating the Fourth Amendment because he would have been going into that chat room as a matter of right, wouldn't he?
Yes, Your Honor. A federal agent could have gone into the chat room. However, in the case of Barr, that did not happen. And the most relevant case to this point is Hoffa v. United States, in which a federal informer turned over content. But in that case, the federal informer received the content and told it to the police. The court did write that a hotel room where the content was spoken is a constitutionally protected zone.
Isn't Hoffa almost exactly on point because an informant came up to Hoffa, and Hoffa thought he was a friend, and he was actually an informer for the police or for the Secret Service, and so Hoffa invited him into his hotel room and made some incriminating disclosures, and the court held that was proper.
Your Honor, that case differs because, one, in this case, no one actually turned over content. And even more, had the government planted a bug into the hotel room and procured of the content, that would have violated the Fourth Amendment.
The bug is different, but we're talking about a human being that could join a chat room every bit as much as Hoffa could have invited him into his hotel room.
Your Honor, just because someone could turn over content does not necessarily mean that the Fourth Amendment does not apply. That implication would mean that by speaking in this room, the government, or in a closed room, anyone could procure of content, and then you would have no sort of security in any interpersonal relations.
Perhaps a better analogy would be if I go into the police station and I have a conversation with a client, and the client starts disclosing to me, his criminal behavior. Well, what expectation of privacy do we have to discuss a case in a police station where ears are everywhere?
Your Honor, I see my time has almost elapsed. May I briefly answer?
Please do. Yes.
In that case at bar, I would believe that would be protected by some sort of attorney-client privilege. However, if you close the door and you enact some sort of security inactions, you have an expectation of privacy, and you do believe that your words will remain private.
But no door was closed here.
Your Honor, the door was metaphorically closed. He did enact these security inactions, and we thus implore the court to draw the line of security on the internet at security inactions.
Thank you, counsel.
Thank you.
Thank you, Mr. Wallach. Mr. Saliba.
Your Honors, and may it please the Court. My name is Alani Salibo, and I arise to address the Court on behalf of the petitioner Chester Comerford on the First Amendment issue. Your Honor, Petitioner Chester Comerford in no way aided or abetted the conspiracy to assassinate the President for three main reasons. First, no true threat existed either on the petitioner's part or on the part of writer Thomas and Peg. Second, the petitioner's actions and comments do not achieve the requirement for imminent lawless action. And third, there was no threat communicated whatsoever by Mr. Comerford.
Counsel, let me take you to your second point about imminent lawless action, and I interpret you're inciting the Brandenburg decision. But in Rice, a significant amount of time passed between the publishing of Hitman and the defendant's murder of the petitioner's friend, a couple of years, in fact. Despite the passage of some time between the statement about President Obama's speech and the speech actually occurring, can't we still infer imminence?
Respectfully, Your Honor, no. The difference between Rice and the case at bar is that in Rice, the court spoke specifically to the explicit nature of the how-to manual, how explicit the instructions were, step by step, how to murder and evade justice after committing that murder. This case is nowhere near analogous to that case, because in this case, we have a situation where American citizen with an inalienable right to participate in political discourse created, facilitated, maintained a group in which he sought to find like-minded dissidents who did not believe President Obama was born in this country. There was no intent whatsoever on his part to start a group and then afterwards have someone assassinate the president, as there was, and Paladin agreed in the summary judgment in that case that their intent was when they wrote Hitman the book.
But didn't the petitioner, in fact, create an electronic brochure through his chat room and through his classroom?
Your Honor, I'll answer your question in two parts. First, with the classroom portion. Petitioner Comerford's classroom activities were that of a law professor who sought to teach his students that there are First Amendment protections that some may be uncomfortable with, especially in the realities of our United States history, where there have been multiple presidents who've been assassinated before. Petitioner Comerford would have been remiss as a law school professor if he did not teach his students about these things. Secondly, the actions on the website, on the private portion of the website, were so ambiguous that there's no way a true threat can be determined from them. And the actions in the public website, the brochure, Your Honor, were all about the birth of movement and nothing about assassinating or threatening to assassinate the president.
But counsel, can't we infer from the context of the website in which the chat room messages were made, the law school hypotheticals, the outburst in the dean's office, and the Casey Ryder's possession of guns? Can't we infer a threat from those circumstances?
Respectfully, Your Honor, we would refer to the court's decision in Brandenburg versus Ohio, where the court says that the state cannot forbid the mere moral impropriety or moral necessity for an abstract teaching of resort to violence. This would fall in that abstract teaching doctrine. Mr. Comerford's actions in classroom and on the website were all abstract and theoretical discussions. His comment about wondering if there are Oswald among them was very akin to a law school professor using the Socratic method. And even if that question is uncomfortable, there is no way there could be a correlation between his question and his enthusiasm or the speaker's enthusiasm for a specific result.
Counsel, I would agree with you that the law school hypotheticals and the outburst of the dean's office would not among themselves classify as threats. But in the threat analysis, can't it provide context as to the petitioner's mental state? And I mean with respect to whether he intentionally and knowingly communicated a threat.
Your Honor, again, we would point the court towards the Brandenburg decision again. In that decision, the court cited Noto versus United States and said, eloquence may set fire to reason, but the difference between an expression of opinion and the enthusiasm for imminent lawless action is the speaker's enthusiasm for that result. We would argue that Mr. Comerford did not have an enthusiasm for the result that Ryder, Peck, and Thomas intended. That even though his words may have been eloquent, they did not start the confrontation that the Secret Service then investigated amongst Ryder, Peck, and Thomas.
It seems hard to believe that it's just the enthusiasm that can make or break your case. It seems that if it was a cold-blooded killer who was bent on killing the president, might not have the enthusiasm because he's just a psychopath and just wants to kill. There's no glee in his intent. Is that where we want to draw the line?
Your Honor, I'll answer your question in two parts. I do not believe specifically that the court meant enthusiasm in the term of glee, but rather enthusiasm in the wanting of that action to be executed. Secondly, not that enthusiasm is enough to decide the case, but rather enthusiasm is part of the process for imminent lawless action. Your Honor, moving on to Rice versus Paladin. Again, the difference between that case and this case is the specificity that was in the how-to manual. There is no specificity in this
But
case.
Counselor, isn't this chat room discussion merely a working draft in progress on a means by which to assassinate the president?
Your Honor, respectfully, no. All of the evidence in the record that the government uses to then force Ryder, Pegg, and Thomas to plead guilty happened outside of the chat room. There are no statements inside the chat room that say clearly and definitively that the intention of Mr. Comerford and the Guardian members was to assassinate President Obama. Furthermore, we would say that the respondents, the government, would like the court to see evidence of things not seen. The record states clearly that all of Mr. Comerford's remarks were so ambiguous that they cannot be taken as a true threat or as enthusiasm for the execution of an action.
Well, counsel, okay, say hypothetically that we disagree with you that there is a true threat. Can you explain to me why the petitioner did not aid and abet under the statute?
Your Honor, even if there is a true threat, we would still argue that the petitioner did not meet the requirement for imminent lawless action, specifically because of the notto quote of the enthusiasm for the result. Furthermore, comparing this case to United States versus Freeman, in that case, Freeman advocated for a group to evade tax law. And in that case, the court decided that that abstract teaching is not the same as stealing a group to action. And the same would be here. Mr. Comerford's actions in the classroom and in the chat room are akin to abstract teaching and that moral impropriety and necessity for resort to violence, which is not the same or synonymous to illegality.
Counsel, all right, I'd like you to put yourself in our shoes here. We have to draw a line between protected and unprotected speech. Can you give this court an example of unprotected speech that would be a true threat, perhaps that would be said in this chat room?
Your Honor, a good example would be in United States versus Fulmer. In that case, Fulmer made a comment to a Federal Bureau of Investigations agent about silver bullets, and the court decided that using the national backdrop, the fact that the Oklahoma City bombings had happened before that, the fact that the petitioner, the respondent in that case, Fulmer, had made various statements to the FBI agent, they could be considered a true threat. The same is not here. The ambiguity in this case is not like the one in Fulmer, but Fulmer would be a good example where the court could draw a specific line in the sand. Your Honor, my last argument would be that if the court were to fail to recognize or fail to agree with the petitioner, that the court would be, in essence, chilling the First Amendment and creating a slippery slope where the government would be able to hold citizens who do not participate in criminal activity directly responsible for the rogue actions of other people.
But counsel, we have said several times, I believe lastly in Watts, of the serious nature of threats against the president as an elevated individual in our society. I'll let you answer this question. Please do. Can't we consider that in whether or not we're having a chilling effect by holding this not protected speech today?
The court most certainly has, and so does the government, a compelling reason to protect the President of the United States. But what we are arguing is that because the petitioner does not meet the imminent requirement, does not meet the true threat requirement, and does not meet the communication requirement, if the court were to hold him allowable, the court will be creating a slippery slope. I'm sorry,
No, please go ahead. Yes.
The court will be creating a slippery slope where people who are not directly involved in criminal activity are held responsible just because they started a group under their First Amendment. And this is something the court should certainly seek to protect citizens' First Amendment in this case and others, and of course in this century and others as well. Thank you.
Thank you, Mr.
Thank you,
Scoobo.
counsel.
Mr. Compton?
Mr. Chief Justice, and may it please the court, my name is James Compton, and today, along with my co-counsel, Mr. Ben Williamson, we represent the respondent, the people of the United States, in the case at bar. I'll be arguing issues pertaining to the Fourth Amendment for the people, and my co-counsel will be dealing with issues pertaining to the First Amendment. I'll be advocating that this court uphold the ruling of the 14th Circuit Court as it pertains to Mr. Comerford's Fourth Amendment rights for the three following reasons. First, Mr. Comerford's Fourth Amendment rights were never implicated in the search of his chat room because it is not constitutionally protected. Second, independent of the Stored Communications Act, this search ought to qualify as a reasonable search for issues of national security. And third, even if the SCA is determined to be unconstitutional, the evidence gathered in the search in question ought to be admitted in trial because the officers acted in good faith reliance upon the Stored Communications Act. So looking first at the constitutional protections that surround Mr. Comerford's chat room, and the respondent would contend that there are none. When we look at the record pertaining specifically to cases where an individual voluntarily conveys information to a third party, this court simply has never held that in that case that the information is protected by the Fourth Amendment.
Aren't the parties receiving these chat room communications actually second parties? They're not some unknown. Well, they are unknown, but it's members of a specific group who agree with the birther movement. So, I mean, we're splitting hairs here, but aren't they actually all in the same group here? This isn't a third party that's eavesdropping.
We have a fundamental difference here, something that's akin to the case of United States versus Miller. The ISP in this case is not simply an intermediary carrying information from one person to another. What we have here is an ISP maintaining a chat room. So whether or not they're not just taking information from Comerford and disseminating it to these other people, they're taking the information from Comerford, taking possession of it, recording it, and taking ownership of it, and posting it on a chat room which they own and actively maintain. And so they're not merely taking it and transferring it, they're taking authority over the information and putting it in an area that they own and maintain. And from this we see this is very similar to the case United States versus Miller, where the bank was taking checks that were intended to go to a different recipient. They were given to a second party. But because the bank had to use these checks in the course of its business, because the bank took authority over those checks, the petitioner in that case was held not to have a Fourth Amendment interest in them.
Right, but in Miller, didn't Miller deal with the, as the court put it, purely business-like commercial use of deposit slips and checks? Here we're talking about the personal effects, one's own messages in a chat room. Doesn't that make the case distinguishable from Miller?
The respondent would contend that it does not, Your Honor, for two reasons. First of all, we see that the information that the ISP is conveying is necessary for the ISP to maintain its commercial business. The ISP has to maintain this chat room and post this information to this chat room in order to maintain the integrity of its business. And secondly, the reason that it was important in Miller that these were personal effects, negotiable interests, was because that information gave the bank authority over the checks and the deposit slips. We see that in a similar way, the maintenance of the chat room and the posting of the information gives the ISP, in this case, authority over Mr. Comerford's information. They literally take ownership of the information that he is transferring here. We see beyond even ownership, they take control of the information by posting it to their own chat room. And so for that reason, we can see that in this case, there's no implication of Mr. Comerford's Fourth Amendment rights because he's ceded authority over his information to a third party, which this court has always held voids one's Fourth Amendment interest in information.
Counsel, I disagree with that. In U.S. v. Jacobson, didn't we hold that it would be unreasonable to search a letter or a sealed package in the custody of the post office, that would violate the Fourth Amendment rights of the seller?
Absolutely, Your Honor. In United States versus Jacobson, we see again a large distinction from the case at bar. In Jacobson, the Postal Service merely takes the letter, never looks at it, never takes possession of it, never takes ownership of it, and merely transfers it from point A to point B. Similar to what happens in like a phone call or a situation like that, or emails in Warshak. What we have here is something significantly different.
But counsel, getting back to Jacobson, doesn't it say that letters and other sealed packages are effects that are protected by the Fourth Amendment? How would you analogize a letter? How would you distinguish a letter and a sealed package from a protected chat room correspondence in a private area? How would you distinguish that?
Absolutely, Your Honor. To somewhat crudely literally take what happens in a chat room and transpose it upon a physical form of communication, instead of taking a sealed letter and delivering it from point A to point B like a mail carrier does, what the ISP is doing here is taking the sealed letter, opening it, looking at the letter, and then posting it on a billboard that the ISP owns and maintains. What we see here is there's a significant difference here from what the Postal Service does. This is something that clearly would give the ISP authority over the information and if it were to occur in a physical sense.
But weren't they contractually bound not to disclose it and not to open it?
They are contractually bound not to disclose or monitor it, but they must by necessity open it in order to post it on the chat room. They have to have some sort of access or authority over it in order to maintain the chat room in any sort of consistent manner. And so what we see here is that if we uphold the doctrine of the Sixth Circuit Court of Appeals in United States versus Warshak, that certain forms of physical communication are analogous to certain forms of electronic communication, we can see that this doctrine actually annihilates petitioner's claim to Fourth Amendment protection in this chat room.
You seem to be saying that the Denolf Communications is taking an active role in opening this. It's not just happening instantaneously through computer servers. It seems like when you analogize it to the Postal Service, they don't open the mail, but that would take a person to do that if they decided to. Here, they are opening it, as you say, but it's happening through a computer. It's happening instantaneously every nanosecond that somebody types on the computer.
Absolutely, Your Honor. And actually, if we look at the precedent set by this court in Smith v. Maryland, this court held that it doesn't matter whether a computer does something or a human being does it. All that matters is the fact that the business has access to and can look and has authority over the information. In Smith v. Maryland, a computer was no operator looked at the telephone numbers that were being dialed and said a computer did it. But this court held, even though petitioner contended that that would preserve his right to privacy, this court held that it did not. The computer's involvement in that communication, there was a sufficient involvement to deny petitioner his Fourth Amendment rights.
But Smith is factually distinguishable from this case. It would be different if we were to, for example, look at when Mr. Comerford posted chat room messages and to whom he posted them, as opposed to looking at the contents. Likewise, in Smith, what numbers Mr. Smith dialed, not what he said once those numbers were dialed.
Absolutely, Your Honor, it is factually distinguishable. The respondent agrees, but in principle, it is the same. What we're seeing here is that the distinction between substantive communication and the actual telephone numbers in Smith was a factual distinction the court made, not necessarily a substantive one. They didn't ever deal with substantive communication in that case. They never addressed that issue.
All right, counsel. Let's say that, hypothetically, we disagree with you that there is an expectation of privacy and the statute is unconstitutional. Can you state the case for respondent for good faith on behalf of the police?
Absolutely, Your Honor. What we see, and something that really wasn't addressed by opposing counsel, is that if, as this court established in Illinois versus Kroll, even if a statute is unconstitutional, if an officer relies upon it in good faith, the evidence he obtains ought to be admitted at trial. And the reason that was given for this is that it's not fair and it doesn't further the purpose of the exclusionary rule to punish an officer for the failures of the legislature. So what we have in this case is we have a statute that may be ruled by this court to be unconstitutional. We have officers who we cannot place upon them the burden to know whether or not the technical details of a statute are unconstitutional. Therefore, because those officers relied on the statute with the full belief that it was constitutional, they are allowed to omit the evidence that they obtained from this search that was executed in good faith at trial, and in this case, the trial of Mr. Comerford.
Counsel, are you saying that the police or the government should be entitled to turn a blind eye to the constitutionality of a statute just because it's there and assume that it's constitutional?
Absolutely not, Your Honor. What this court ruled in Illinois versus Kroll is that indeed this court can rule the SCA to be unconstitutional, and when it does so, the government can no longer rely upon it. But if an individual officer cannot be charged with the knowledge that a statute is unconstitutional, it doesn't further the purpose of the exclusionary rule to eliminate that information. The purpose of the exclusionary rule is to discourage warrantless searches, discourage searches that are unconstitutional. And to tell an officer that he can't execute a search under a statute that he doesn't know is unconstitutional fails to further that purpose and unfairly punishes an officer who's relying upon a statute that he doesn't know is unconstitutional.
Well, first of all, we're talking about punishing the officer. What about the defendant? But in the case of Kroll, that was the decision that the statute was unconstitutional came after the search and seizure in that case. But in the present circumstances, the Warshak decision came down prior to the execution of this warrant. Isn't that correct?
Yes, Your Honor, and 3 points on the Warshak decision. First of all, that case was decided in the Sixth Circuit, which is not binding on the 14th Circuit, which is what we're talking about. Secondly, it was decided only 5 days prior to the search in question. And third, it was ruling on a separate section of the statute of the SCA. The Warshak court specifically ruled on a statute of the SCA that applies to emails and communications which are not stored. The section that was used in the search in question is an entirely different section of the statute.
Well, doesn't the statute just pertain to electronic communication? communications. It doesn't state emails or chat room correspondence.
There are actually two different sections of the statute, Your Honor. One of which was used in Warshak, and a separate one which was used in the case in question.
Counsel, one last question, and I realize this will take you over time. I will allow you to answer this question. You mentioned the test in Kroll about the objective reasonableness of officers, which is limited when the legislators ignore their constitutional imperative. So can you explain to me why your point about national security would lend itself away from the inference that the legislators have, in fact, abrogated their constitutional duty here?
Well, in fact, Your Honor, the national security argument is slightly separate from the good faith argument. But to sum up the national security argument briefly, respondent would contend, first of all, that the Fourth Amendment only protects against unreasonable searches and seizures, and that this court has reserved the question of searches for the purpose of national security in Katz versus the United States. And we would ask this court to take up that question and allow the Secret Service and questions of defending the life of the president to execute searches without the imposition of a magistrate to better protect from the significant threat to our national security that can arise from a substantive and actuated threat to the life of the president.
Thank you. Mr. Williams.
Mr. Chief Justice, and may it please the court, my name is Ben Williamson, and I also represent the respondent, the people of the United States of America. And as my co-counsel said, during my time, I'll be addressing the issue of the First Amendment regarding the argument of whether or not Petitioner Comerford's moderation of a chat room in which conversations pertaining to allegedly threatening the President of the United States was not protected by the First Amendment, and this is for 3 reasons. The first reason is that the context of Petitioner's website, combined with the content that it contained, indicate that Petitioner Comerford had a clear and present intent to do injury to the President of the United States. The second point is that the statements on the website made by Pegg, Ryder, and Thomas could have been interpreted as a true threat by the standard of the interpretation of any reasonable person. The third argument is that Petitioner Comerford met the definition of aiding and abetting a true threat to the President of the United States as established in prior case law.
Counselor, let me ask you a hypothetical question. If I open up a bar in which everybody supports the birther movement, and patrons of my bar begin discussing ways in which to kill the President of the United States, but whether I do or don't know about it, would that make me liable for aiding and abetting a plot to kill the President?
Certainly not, Your Honor. And United States v. White established this point when it said that just opening a forum for discussion does not hold one liable for what goes on in that forum. The simple idea of opening up a forum does not hold one guilty of aiding and abetting a true threat.
But isn't that what Mr. Comerford did here? He opened a chat room for people who agreed with his viewpoint, and they just happened to want to eliminate the President?
Your Honor, the petitioner certainly did open up a website for people who agreed with him regarding the birth of the president, but that's not the only thing he did, and that leads us into the point of context and content. He's guilty of more than just opening up a website. The website itself would not hold him guilty. The fact is, what he did after that is what should hold him guilty of aiding and abetting a true threat. Now, this court established in 1969 the importance of context when we talk about threats to the President of the United States. And in that case, basically what the court did is examine the fact that the members of the political rally, when Watts made the statement threatening Lyndon B. Johnson, they recognized that the other members of that political rally laughed in response to his statement, clearly taking the context of his statement into account. Moreover, Planned Parenthood versus ACLA suggested that courts should take all the facts into account when judging the legitimacy of a threat. So in this case, what we can do is recognize 3 pieces of context that indicate the mindset of Petitioner Comerford going forward into the chat room. 2 of them deal with his hypotheticals going into his law class, and 1 of them deals with the website specifically. Now, the first thing we want to deal with regarding context is the issue of hypotheticals. Now, the facts are clear that Petitioner Comerford presented several hypothetical issues regarding the assassination of President Obama, or the president, some of which mention President Obama by name. And the facts also state that over time, Petitioner began to actually sort of almost justify the assassination of the president in his class by having his students sort of talk themselves out of or justifying if they were to assassinate the President of the United States.
Counselor, isn't that the purpose of a law school discussion, to argue both sides of a case, whether or not the defendant's beliefs are reprehensible?
Absolutely, Your Honor, and that's where the key distinction arises. The respondent certainly does not believe that just because the petitioner presented these hypotheticals, he's guilty of aiding and abetting. This is simply context. However, context does provide a background and a precedent for how we can view the other things that the petitioner did. Respondent wants to make it clear that we don't believe because petitioner presented hypotheticals in his law class that he's guilty. All we're doing is using that as background for further...
Counsel, in Watts, the statement was very direct. It was directed towards the president. He made it very specific to killing the president, putting him in the crosshairs. But the context saved him because it was viewed as humorous among the audience. Here, we only have the context, and the specificity of any kind of a threat is not there. So which is greater, the context or the specific threat?
Your Honor, respondent would respectfully disagree that we lack content in this situation. We believe we actually do have content. For example, we also want to clear up a factual dispute. I believe my opposing counsel mentioned that Petitioner Comerford asked the question of whether or not there was an Oswald among them. That was actually Casey Ryder that asked that question. Petitioner Comerford was the one who actually responded to that question. And his response was sort of interesting. What he said was, "It's a good question. I wish I knew the answer, but don't we all?" Now, right there, we see an encouragement of that type of thinking within the website. When someone referenced Lee Harvey Oswald, the assassin of John F. Kennedy, instantly his response was, "It's a good question." That in and of itself is encouragement. So we don't lack content here. We have some elements of content. The context just provides backdrop for what else went on.
Counsel, you mentioned our 1969 decision in Watts versus United States, but you haven't mentioned Brandenburg v. Ohio, where we said that the speech was protected except where the advocacy is directed to inciting or producing imminent lawless action and is likely to incite or produce such action. Now, these events occurred 6 months prior to the time that President Obama was scheduled to visit the campus. How can that be said to be imminent?
Yes, Your Honor, and Brandenburg versus Ohio essentially did draw a line between abstract advocacy and overt action, but respondent essentially believes that Brandenburg, Ohio really supports our position as well, and the reason is because the statements within the website went beyond abstract advocacy.
But where's the imminency?
The imminency really deals with things that went outside the website, but there are some elements of imminency within the website. For example, several of the members of the message board were making travel plans and arrangements to visit where President Obama was speaking.
In 6 months.
Yes, but Your Honor, when we're talking about the legitimacy of the threats, we should take into account that several other statements were said.
Let's assume the threats were legitimate. We're still talking about imminency. Where's the imminency? 6 months.
Your Honor, the imminency is there in regards to the fact that President Obama had been threatened several times on the website through vague sort of statements when we look at it in the big picture. So just because the fact that he was going to be speaking in 6 months does not necessarily disregard that there was a true threat that Petitioner Comerford should have stopped when he saw it. We agree that Brandenburg, Ohio does in fact support our position on this matter. Now,
Counsel, let me ask you another hypothetical. If I'm speaking with my friend who has just lost his job and he blames it on President Obama and he says, "I'd like to put 2 in his chest and 1 in his head," and I say, "Go for it," would I be aiding and abetting that person?
Not necessarily. Well, Your Honor, there'd be more facts necessary because, number one, we'd have to determine the context of what he said. Is the context legitimately seem to indicate that he's actually willing to follow up on that concern? But this actually also leads to a distinction.
So how can Mr. Comerford see from context, just text on a chat room, what the people who are writing these messages, how does he see what their context actually is beyond the words on the on the computer screen?
That actually leads us to the third issue of context, which was the change in the demeanor and the sort of aura of the website after 2010. The facts state that after 2010, when the GOP really took over Congress, once that transition was made, the discussion of violence really elevated within the discussion of the website. And the reason for that was that the GOP did not follow up on requests to investigate the birth of President Obama. So the facts give several recurring preceding statements that really are questionable and sort of threaten the life of President Obama. So that issue of context really comes to the sort of attack of the other 3 members of the website. Prior to 2010, we can see the language of the website essentially becoming violent. And specifically, we can address, first of all, the Oswald statement made by Casey Ryder, then questioned, then responded to by Petitioner. But we can also look at the fact that these members of the board lauded and really applauded the attempted assailant of Representative Gabrielle Giffords of Arizona. But not only did this attempted assailant try and kill Representative Gabrielle Giffords, he killed a little girl and a chief justice, or a court judge. So not not only was this an attempted assailant, he was a murderer, and the members of this website were encouraging and advocating that activity. This should have alarmed Petitioner Comerford, yet he sat by and did not do anything.
But Brandenburg advocated separation of races, a concept even this court in 1969 found reprehensible, but we still held that mere advocacy is still protected under the First Amendment. Can you distinguish the two?
Well, Your Honor, that really dealt with abstract advocacy, and that's the key distinction. Abstract advocacy is legitimized under the Supreme Court. This clearly went beyond abstract advocacy. That change in context from 2010 and going on, the context of the website indicate that the advocacy going on in the website was no longer abstract. Petitioner Comerford should have recognized this, and yet he did not. The facts are clear that he was present at all times during the discussions on the website, and the entire time he did nothing. But so this really looks at the issue of the big picture and a distinction in between the viewpoint of petitioner and respondent. Petitioner seems to want to look at the individual statements of Peg, Ryder, and Thomas, and even of Petitioner Comerford, and analyze them individually. Now, even if this court were to find that the individual statements are somewhat vague, respondent believes that we should look at the big picture. Even if you find these individual statements to be vague, the big picture shows that a threat was present. Basically,
isn't the big picture just that these people are venting and making travel plans to go see the president is perhaps one of the most ultimate First Amendment rights we have?
Well, Your Honor, even venting, when it goes beyond abstract advocacy, is liable for First Amendment, basically not under First Amendment protection. If it's no longer abstract, then it becomes a crime. Petitioner Comerford sat by with essentially a silent satisfaction, seeing what was going on in the website and doing nothing. And it's for that reason that we would urge the court to uphold the ruling of the lower circuit. Thank you, Your Honor.
Thank you, counsel.
Thank you, Mr. Williamson. Petitioner, rebuttal. May begin?
2 minutes. Your Honors, 2 points on rebuttal. I'd first like to address the Fourth Amendment issue. The respondent would like to make the contention that the chat room contents were business instruments in the aspect that the Denolf Communications had access to and use of the content by looking at the content and transposing them. However, they distinguish email, yet the difference is minute. Simply by transposing the content and putting it from one forum to the next, emails and chat messages are exactly the same. We thus urge the court to adopt the ruling in Smith, which held that it was acceptable for the government to look at the actual existence of communication, but not the very content. As ruled under Katz and as elicited and even further compounded in Smith, the government may not subpoena the telephone company to look at the content of the chat or to look at the content of the conversation. In the same regard, the government cannot ask Denolf to turn over the content because it has no bearing. They simply transpose one message to another. What is said makes no difference. And even further, on the First Amendment issue, all the comments made by the petitioner were simply abstract statements, and they were theoretical. He is allowed to ask questions as protected by his First Amendment rights in Brandenburg versus United States. He is simply propagating certain ideas. He is asking Socratic questions, such as the law professor that he was. By infringing upon his right to have an abstract thought and ask questions, that would be violating the First Amendment in a grand way. And the Fourth Amendment implication would lead that anyone, even in emails, as found in Warshak, would be able to access the content just because they look at it. This is not a good comparison could be made regarding the relationship between a landlord and a tenant. The landlord has access to a tenant's room and even control over things like heat and fixing appliances. Yet a tenant still has privacy in their realm, and the landlord may not consent to a search. Thus, we ask the court to disregard the arguments of the respondent. Thank you.
Thank you,
Thank you, counsel.
Thank you.
You can all wait here while they deliberate.
Okay, so that was good. So to relieve you all, there are no more questions. We're all done. Excellent job by both teams. It was not a unanimous decision, but this year we voted in favor of the respondents. Generally, I give individual feedback. I'm not going to do that at this late hour. I will just say briefly that the advocacy just got better as the day went along. The mistakes I saw, the critiques kept getting more and more finite and more picky as the day went on. And it just goes to show how fantastic the advocacy was on both sides. Thank you. That's all for me.
My general comment is that when I've done this and you're arguing on brief and off brief, I'm not sure which way was which for you, but it feels like you're lying sometimes when you're arguing off brief. If you've been on brief a few times, off brief a few times, and then when you're at the end, if you're off brief, you just think you're lying, and it's very hard. I felt exhausted, and I'm just asking questions. I don't have to worry about winning anything today. Amazing performance by both sides. The people who went second for both teams, just real cool. I think I told you that during the previous round, 60 beats per minute the entire time, and the same with you over there. I'm sorry, I forget your name, but excellent job.
Just very briefly, as a practicing attorney, I just want to thank you for giving me a breath of fresh air, because this is the reason why I went into the law. And I'm hoping down the road I don't have to go up against you, that's for sure. But certainly your hard work and effort that you put into this has totally paid off. And I mean that for everybody that I saw today. You came here, you were prepared, and you did an awesome job, and you should be commended, and I wish you all the best of luck in the future.
Yeah, just a year ago, where you guys were. I was arguing on that side of the podium, and it brings me back to how difficult it is to maintain the calm nature and stature that you have behind the podium. And every single one of you has that cool and collected tone. Great use of time. You're smiling. You're looking at us. No breaking eye contact. You're looking like you're having a good time. You know what you're talking about. And that is what definitely makes a good advocate. It's not necessarily that you have to have the best argument. We don't even grade on the merits. It's that you are looking like you know what you're talking about, because that makes it look like you have the better merits, even though that's not the point. The best thing I can say is that for James, the answer to my computer question, spot on. It was to the point you didn't have to go around it. So I just wanted to single you out and say that's exactly what I was looking for.
I just want to say, I guess I'm the elder statesman here. I've been practicing for 28 years, and I think there's a few people here that probably weren't around when I got sworn in. Be that said, I'm not 60, so I'm not that old. I like coming back and doing this every year because a little bit of what Dave said. Dave and I practice in neighboring towns. He's in Winchton, I'm in Ashburnham, either of which you probably ever heard of. But you come back here, and it kind of brings me back to when I was in law school, and we had moot court, and it's just really kind of, I guess, refreshing is a good way to put it. But all of you did a fantastic job. You guys heard me say this in the last round, and I'm going to say it again. I argued a case in the Mass Appeals Court back in May. We won, but not for the reasons I argued. And you didn't have to laugh so loud. But you guys are all, in fact, I said the last time you were as good as, I think you're head and shoulders above many of the attorneys that I saw in the court that day arguing cases. And we're one notch before the high court in this state, which is one of the most respected state high courts in the country, as I learned in law school. So it's a lot to be said for what you did. And you were a pit bull. I was trying to zip you on that eminent, and you kept coming back, and you did it in a very excellent way, very strong, very aggressive, but polite and respectful. There's an attorney who's now retired named Tom Carroll, and maybe some of the people here might know who he is. But he used to be a district court judge in Gardner, and of course the first thing you come out and you start practicing, it's like, that guy's a judge. You don't want to get him upset. When you walk around on eggshells. And he told one of my friends, he goes, I hate it when lawyers do that. But he's the type of guy you'd get into a lot of give and go. And he was a real joy to practice in front of him. Just to share one little story about it that I told him this year, now that he's retired. But we had a thing we used to call the Tommy Carroll growl. And whenever you were trying to plead out a client in there and the DA didn't agree with what you wanted, we'd bring it up as what's called, it's a plea, but it's an uncontested disposition. And once Tommy Carroll started yelling at your client and giving him the standard, I don't ever want to see you in my courtroom again, you knew he was going to give you what you were looking for. But the thing is, again, is that was a good thing you did, and keep it up, all of you. You just did a tremendous, tremendous job.
Thank you again, and great job by the judges as well.
Thank you.
Finalists, team number 37, Mr. Layvon Ball. And that means our champions for 2011. Team number 20. And again, Patrick Henry College on another champion.